In a world that's always racing forward, sometimes we need to slow down and reconnect.
Connect genuinely, broaden your perspective, and share your passion.
Bona Fide Dialogues, where authenticity, creativity, and passion merge. Mr. Grossman is a founder of Intelligent Justice. He is an experienced trial lawyer, focused primarily on complex business litigation and alternative dispute resolution. His practice has included legal disputes covering a broad range of issues, including business fraud, antitrust, contract disputes, trade secret litigation, licensing disputes, class action litigation, real estate and construction disputes, employment and intellectual property litigation. Mr. Grossman has appeared before federal and state courts at both the trial and appellate court levels. He was the chairman of his prior law firm's litigation practice. Concern over the extraordinary cost, delay, and inefficiency of obtaining justice in the public court system motivated Mr. Grossman to seek better dispute resolution alternatives and ultimately led to the creation of Intelligent Justice. He has broad experience in arbitration and mediation procedures, but he is especially passionate about the virtues of Intelligent Justice's Comprehensive Adjudication, which provides the most cost-efficient path to a fully analyzed, thoughtful, and just resolution of legal dispute. Notable cases: UFCW and Employers Benefit Trust versus Sutter Health. Lead counsel in a groundbreaking antitrust class action battle against Sutter Health, the dominant hospital chain in Northern California, on behalf of a certified class of employers and other self-funded payers who were overcharged for healthcare services provided to their employees as a result of Sutter's anti-competitive contracting practices. Result: $575 million settlement for the overcharges imposed upon the class, plus at least 10 years of comprehensive injunctive relief to prevent future anti-competitive behavior. Antitrust litigation against Microsoft. Multiple cases on behalf of Microsoft's software licensees and a separate case on behalf of a competitor for unlawful restraint of trade and unfair competition in the operating system and key business software markets. Microsoft cases: co-lead counsel in an antitrust class action on behalf of Microsoft's business and consumer licensees in California. Result: $1.1 billion settlement. San Francisco versus Microsoft, co-lead counsel in an antitrust class action on behalf of Microsoft's government entity licensees in California. Result: $70 million settlement. Gordon versus Microsoft, co-counsel in an antitrust class action on behalf of Microsoft's business and consumer licensees in Minnesota. Result: $182 million settlement after 6 weeks of trial. Sun Microsystems versus Microsoft, co-counsel assisting in antitrust claim on behalf of Sun Microsystems. Result: $700 million settlement.
Thank you very much for joining me today. Can anyone truly protect their rights in this country? Is achieving justice possible?
Well, thank you, Christina, for having me. I'm delighted to be with you today. Our public court system is extremely flawed, and I know this because I have been a participant in that system for many, many years. I participated in that system as an advocate for plaintiffs that had very legitimate claims and were legally wronged and deserved relief. I also represented defendants that were the victim of improper claims, illegitimate claims, and needed to be defended. In every one of those cases, the public court system let the parties down. What do I mean by that? Well, in most of those cases, I was victorious, on behalf of my clients by the standards of our public court system. We achieved most of the goals that we sought out to achieve in the litigation. But did we achieve justice? Justice. And I think the answer to that is not always. The reason is because our public court system is so inefficient, it is so costly, it requires so much duplication of effort. Attorneys' fees are too high. It takes years to achieve a result that is final and enforceable. And the risk of an unjust outcome is far too high and unacceptable. And so we have a system where the cost of pursuing a just outcome is rarely worth the benefit that one could possibly achieve, even if you're victorious. So while I achieved victories on behalf of most of my clients when I was a legal warrior, an advocate on their behalf, did I achieve justice? I have to question that. If they have to pay too much money in legal fees, if they have to, if it requires years to obtain that victory, if the risk of an unjust outcome is too high to gamble on a judge or a jury deciding it, then that's not justice, and it's not a proper justice system. And so I have, because I've been disheartened by that, because I actually care about justice and bringing justice to our society and making it available to those that have been wronged, I decided to come up with a better system that makes it affordable to swiftly get to the right outcome in a legal dispute, and does it in a way that is cost-effective, is swift, and is just. I call it comprehensive adjudication, and we can talk more about how it works.
Learn more at casesresolve.com and intelligentjustice.org. Consider Comprehensive Adjudication provides a more expertly analyzed enforceable decision in less than half the time needed for litigation, at less than half the cost required for litigation. The total cost is capped in advance.
I know that you have been practicing law for so many years. How many years actually have you been practicing law?
Over 40 years I've been practicing.
Over 40 years, yes. And you worked on so many important cases. But do you think that this new system that you will be talking about in a moment is applicable to any case, or specifically to those large cases?
Comprehensive adjudication, this new system that I came up with, can be utilized in small cases or large cases on almost any subject involving any area of the law. So it can be utilized in a divorce dispute. It can be utilized in a dispute over a will or an employment dispute with your employer. It can be utilized in large antitrust cases, in patent cases. It can be utilized in contract disputes between individuals or between corporations.
Public court litigation requires many years to complete because an enormous amount of time is wasted on procedural battles. Comprehensive adjudication eliminates that wasted time by focusing exclusively on the key legal and factual issues. Mr. Grossman dedicated significant time to litigate some cases. At times, it took years. While he is proud of his successful outcomes, he wishes the process didn't take as long. Here is an example from his practice.
I'm proud of almost all the cases I worked on because I have had the luxury of choosing the causes that I wish to advance through my legal advocacy when I was acting as a legal gladiator on behalf of my clients. But yes, I have been involved in some cases that were very complex and required a long time to recover. I worked on behalf of an inventor who came up with a fabulous energy-saving lighting technology in many, many years ago that would have saved 30% of our energy costs over the past several decades if it had been implemented. It was then licensed to a large company that had an old energy wasting technology that it was selling, and it promised its best efforts to bring it to market. But what it did, instead of using best efforts to bring it to market, the energy-saving technology, it buried it. We filed a lawsuit to bring that technology back to the public and to recover the losses that the inventor sustained as a result of that case. We tried it and won $28 million. That got reversed on appeal because of an evidentiary issue. We had to go back and try it again, and the second time we tried it, we won $96 million. That was ultimately sustained on appeal up to the California Supreme Court, but before we were able to have a final judgment that was enforceable, it took 14 years. And, a large part of the client's recovery was paid in attorney's fees. You can imagine what they were over a period of 14 years of full-time work.
And the technology that he created was probably no longer as important as it was 14 years ago, right?
It was buried during the time when it would have been most useful. So is that justice? Yes, we won. Yes, we won a lot of money. But is that justice when it takes 14 years to get to a proper result? And is it justice when the vast majority of the recovery goes to the attorneys? I would say it is not.
And so many people won't be able to pursue such a long lawsuit. To make it a part of your budget, you really have to sacrifice so much in life. And most people won't even do it, then they will look at the financial aspect of that. They would say, I can't protect my rights in these situations. I can't afford it. It's not justice. If you can't even go to court to protect your rights, knowing how much it's going to cost.
Absolutely. And that is the problem. And it was worthwhile when there was so much at stake that the attorney's fees didn't eat up the entire recovery. But I cannot tell you how many times I had to advise potential clients the cost of pursuing a just outcome will approach or exceed the benefit that you could possibly obtain many years down the road. And so I would decline to take cases, even some very large cases, because it was not worth the client's investment of time and energy and cost to obtain what would have been a proper result, but a result that would have been eaten up by attorney's fees, delay, and the risk of an unjust outcome.
Yeah, it's not always only attorney's fees, right? There are experts involved. If there's a discovery stage of litigation, can be extremely costly. So yes, how can you predict? It's not always even possible for you. Then I assume then you advise your clients or potential clients. If I come to you tomorrow and say, I'm in this situation, how much it's going to cost? Like, it's hard to make that assessment. And if it takes 14 years, or even 4 years or 5 years, how can you possibly give that advice? So something is really wrong with our system.
I agree. And it's not the fault of the attorneys. The attorneys are working within a system that motivates and incentivizes inefficiency, incentivizes battle and advocacy, as opposed to incentivizing a swift and cost-effective system for obtaining justice. And so I challenged myself to come up with an alternative. What would I replace our current system with?
What can we do? It has to be changed.
Well, in order to understand the solution, you have to understand the problem. And let's just talk about why it costs so much money to pursue a just outcome in our public court system. The principal reason is our public court system is structured around, it depends upon each of the parties to a dispute hiring separate lawyers that all review and research the same legal authorities, that examine and review the same evidence, that examine the same witnesses in depositions, in discovery. The problem with having a legal gladiator on your side is that the other side also has a legal gladiator emphasizing the law and the facts that support them. And they tend to cancel each other out. And so wouldn't it be better, more efficient, more cost-effective, faster, and more accurate to have a legal system where we weren't emphasizing the battle between legal gladiators?
But then you don't see different perspectives, right? You have two people and they're looking at the same situation from different perspectives. So then the judge can listen to both of them and find the truth. And of course, the evidence as well.
Well, perhaps we should talk about the solution that I've come up with, because it solves that very problem. The public court system relies on separate advocates making presentations to a judge or jury in a battle before the judge and jury that they hope to win on behalf of their clients. My solution is that's a waste of time. It's a waste of time and effort. And it would be better to simply hire an adjudicator, someone with expertise in the area of law that's relevant to the dispute, and someone with expertise in reviewing the evidence, analyzing the evidence, examining witnesses, and getting to the truth, to look for all the law and evidence that support the claimant, and just as zealously look for all the law and evidence that support the defendant, and then decide the dispute so that you have a neutral, someone who doesn't care whether the plaintiff wins or the defendant wins, but just wants to quickly and efficiently, cost-effectively get to the proper result. That would be a more efficient, much more cost-effective system for obtaining justice for either the plaintiff or the defendant, whoever deserves to win. And that is what comprehensive adjudication is about. Comprehensive adjudication eliminates the legal gladiators. What we do with comprehensive adjudication is the parties have the ability to hire a patent specialist to be the judge, the adjudicator, if you will, of their patent dispute. You can hire someone that is experienced in domestic relations to be the adjudicator of your divorce dispute. You can hire someone that has experience and expertise in employment disputes.
These are licensed attorneys, right?
Licensed attorneys to be the adjudicator in your employment dispute. And so you get someone that starts out with expertise in the specific area of the law. And the parties will interview experts in patent law.
This is great. I think this is so important. Yeah.
And they will jointly interview their adjudicator candidates and can make selections based on their experience, their expertise, their integrity, their neutrality, and their diligence in working hard to get to the bottom of a case quickly and inexpensively. That is what we're looking for with the folks that we want to decide our cases. And that is one of the tremendous benefits of comprehensive adjudication. But
yeah, so the first benefit, as I hear what you're saying, you're saving a lot of money. Second, you actually can agree on an adjudicator who is specializing in specific area of law and maybe even has experience in that specific field. And the third one, you said that it can be the matters can be decided much faster. How would you achieve that?
Well, let me explain the problem with the public court system.
Yeah.
There's enormous duplication of effort. It is enormously inefficient, and that falls in three areas. Let me quickly explain what they are. First, as I said earlier, you have lawyers for each party researching the same law, reviewing the same evidence, examining the same witnesses, attending the same hearings, examining witnesses at the same trial. While one is examining the witness, the other is sitting there listening. But the parties are paying for both of them to do this work.
Right.
What comprehensive adjudication does is it consolidates all of that work that's being duplicated by the separate counsel for separate parties into a single adjudicator who looks for all the law and the evidence that supports the claimant, as well as all the law and evidence that supports the defendant, and then just decides the dispute. In our public court system, the lawyers for each side first have to uncover the evidence, the documents, the electronic records, and they have to examine the witnesses in what we call discovery proceedings. And those are long, complicated proceedings where depositions are taken, where documents are subpoenaed, where there are fights over the proper scope of subpoenas and the proper scope of depositions. And then after all of that evidence is collected, witness testimony and documentary evidence, the parties, the lawyers for both sides, take that evidence and they make presentations to the court in the form of motions to the court, all kinds of different motions that are necessary before a trial. And what do is they present that same evidence and that same testimony in motions to the court. And then after those motions are decided, they have to present that evidence again to a jury at a trial several years later. And so there's yet another presentation of the testimony and the evidence. And then after there's a decision at trial, they have to present that same evidence again when there's an appeal. And they present that to a separate appellate court, the law and the evidence. And so you have multiple presentations of the law and the evidence to a whole variety of audiences in order to get to the point where you have a final decision. Comprehensive adjudication eliminates all of that duplication. The adjudicator starts the trial, if you will, immediately. Immediately after the adjudicator is hired, the adjudicator looks for and obtains all of the documents, all of the electronic records, and examines all the witnesses under oath. We don't need to repeat that presentation again. The adjudicator, the person who is responsible for deciding the dispute, has already seen the evidence and has already heard the testimony. And so instead of duplicating these presentations over and over and over again with all kinds of delay, years of delay in between, the adjudicator starts the trial right after the adjudicator is hired, finds the evidence, examines the witnesses, and decides the case. And that's how we cut the time involved. There's one more area, and that is in our public court system, because it's an adversarial system.
Yeah.
The motivation of the lawyers is to seek every procedural advantage on behalf of their clients. And so there are all kinds of lengthy, expensive, unbelievably expensive and time-consuming disputes over such things as jurisdiction, venue of the court, discovery disputes over the proper scope of discovery, experts and whether expert witnesses are appropriate, scheduling disputes, confidentiality disputes, disputes over attorney-client privilege and the like. And the list goes on and on. None of those matters, none of those disputes that are the subject of all kinds of expense and time have anything to do with the substance of who is right and who is wrong. It's all about legal gladiators seeking some sort of procedural advantage for their clients. And sometimes they succeed, sometimes they don't. Sometimes one succeeds in this area and another succeeds in the other area. But none of that has to do with who's right or wrong.
Yeah.
Talk a little bit about what expert witnesses are. Ordinarily, a witness in a trial can only testify about something that they actually witnessed, something that they saw with their own eyes or heard with their own ears. And because they have to have what we refer to as firsthand knowledge of the facts of the dispute. However, there is something that we use in the public court system, which is referred to as expert witnesses. These are not witnesses that testify about something that they actually witnessed with their own eyes or their ears. They have particular expertise in something, in a field that is beyond the understanding of regular, ordinary persons. And so you want to hear their analysis and their opinions about the facts that they have been presented with because of that highly specialized knowledge that ordinary people don't have, including lawyers. And so, for example, in a patent case, you might have an expert witness who is a scientist and has specialized training, knowledge, and expertise in a particular area of science that ordinary people don't know or necessarily understand. And you want to hear their analysis. You're right, Christina. In our public court system, each side hires an expert that has an opinion that supports their view of the case and their client's position. And the other side has an expert that supports the other view. And you have these two opinions that clash with one another, and neither of them is about trying to get to the proper result in the case. It's all about this adversarial process of one opinion versus another opinion, one attorney's emphasis on certain facts versus another attorney's emphasis on certain other facts, one attorney's emphasis on certain aspects of the law and another attorney's emphasis on another aspect of the law. Wouldn't it be more efficient, faster, less expensive to have a single adjudicator who's looking at both sides of the case, who doesn't care whether the plaintiff wins or the defendant wins, but only cares about getting to the right result and doing
they can agree on one expert, right?
Well, exactly. In other words, the parties, if an adjudicator believes that there is something involved in the case that is beyond the adjudicator's understanding or ability to comprehend, something involving science or psychology or economics or some other specialty, then the parties can agree that the adjudicator can hire someone with expertise in that area and hear the opinions of that expert in connection with the adjudicator's decision on the case. But we don't need to hire two experts that automatically opposing opinions that are just going to cancel each other out. And so, again, this is another example of waste in our public court system. What is wasted? It's the time and the money of the clients.
What would you say about e-discovery?
Well, let me talk to you about a case that I just resolved not too long ago. It was a large antitrust case. It involved millions of records, paper and electronic records. It involved all kinds of evidence. And you're right. Each side not only had attorneys, a whole team of attorneys working for the two separate sides, but they also had huge teams of document reviewers, analysts, people that crawled through those millions of records one by one to identify where there was something that was relevant to the dispute, where there was something that helped their client's case, and where there was evidence that perhaps would be troublesome for their client's case. An attorney doing their job has a team that looks for both. But the enormous amount of waste to have not only separate attorneys, but having each attorney team have even larger teams of document reviewers going through all of that evidence to identify the evidence that is relevant to this dispute, either good or bad. Again, enormous duplication of time and cost. All of that is duplication that is unnecessary. Yes, the adjudicator will have to also look at all of those documents and will also have to have a team of document reviewers. But having one team of document reviewers and splitting the cost of that between the parties is 50% more than both parties, each reviewing the same documents, each having a team that is doing that kind of analysis. The savings is enormous with comprehensive adjudication. Our public court system is structured around what I consider to be a myth. And that is that out of a vigorous debate between two legal gladiators, one for each side, truth will somehow magically emerge. And so that is the system we have. And all of the inefficiency, all of the duplication, all of the multiple presentations that are unnecessary, all of the efforts to achieve procedural advantages are, at their root cause, is this adversarial system that we have because we believe that magically, out of a vigorous debate, truth will somehow emerge. Well, anybody that's watched the presidential debates, for example, probably has some reason to doubt that truth emerges from a vigorous debate. Anybody that goes into that looking at those debates with an open mind can't tell who's telling the truth or what the proper perspective is. And the same is true in court. Again, to learn more, go to intelligentjustice.org. If you have a specific dispute that you want to explore using comprehensive adjudication to resolve, then go to casesresolved.com.